Good afternoon. Not legal advice. This really is not legal advice. Like, subscribe, share. Please do so. If you get anything out of this, please subscribe, give it to other people. Please absolutely show it to your animals and especially your canines, because again, they love this content. Just a quick word before I go on with three quick topics. Atheism is a non-profit organization. So I wanted to talk about three quick topics. One is the Gtii amended complaint that was filed on September 5th. Two is the Alpine matter, just a brief update as to something else that I didn't talk about previously. And three is Tesla and their new lawsuit they filed in Shanghai. So I'm going to do it backwards. We're going to start off with the Tesla thing. Obviously, you know, at this point in time, I'm a Tesla bull also. So I am invested in Tesla and follow them carefully. So they have a large factory in China, in Shanghai. They have a supplier who's also a designer of chips in Shanghai who was recently sued by them for a claim of theft of technology and trade secrets. And that action is now in the intellectual property courts. So China has intellectual property courts where issues related to intellectual property, surprisingly enough, are adjudicated. So that is going on. Now, what's interesting about this particular matter is it's not the first time there have been thefts in China or alleged thefts of intellectual property. In fact, it wasn't until about 1980 where China even started to respect intellectual property rights of especially foreign companies. But what's curious about this is that the defendant is owned 12% ownership by a company, and I really can't pronounce the name correctly, but it's XIONAMI, which is a big Chinese technology company. Surprisingly enough, it recently got into the EV business and also is interested in autonomous driving, which Tesla obviously is pushing forward. So whether that interest by the owner of the defendant played any role, I'll let you decide. But it'll be interesting to see how this goes forward. It'll be interesting to see if the courts provide protection to foreign companies. Up to this point in time, although I'm not a practitioner, obviously in China, the issues in the intellectual property courts where damages were limited and that it's difficult to obtain the proof that you need to win your case under Chinese rules or the rules of those particular courts. So we'll have to see how that turns out, how that works out. I'll keep you apprised. Two, as I said, I'm working this backwards, Alpine versus FINRA. So I did a video about the appellate brief that was filed by Alpine. And one thing I forgot to mention, in that brief, there was a section because the discussion is about whether a injunction should issue blocking FINRA from their expedited proceeding. And one of the issues in deciding that is the equitable issues, the good faith nature of the parties. So it was amazing to me that in Alpine's brief, there was not one mention of the fact they had been disciplined 40 times previously, that one of their chief members, who they tried to make, in essence, a representative, was literally, this is not figuratively, a sex criminal. And yet they were arguing that the equities went in their favor. I'd be interested, and I hope, that FINRA in the reply brief just goes after Alpine, completely eradicating their status, because I think they're scumbags. And even though to some degree their arguments in the appeal may have merit, they do not. And in the end, they're going down no matter whether the appeal stands or not, just a matter of when. So that was interesting to me that in their brief, in terms of the equity section, they had to argue that they were acting in good faith and it was for the benefit of the public that they prevail. So I just found that kind of astonishing and interesting. And again, if I were on the other side of FINRA and I had the opportunity to oppose that, I would be quite illustrative in my opposition. Again, Doesn't change the outcome for Alpine, just delays the outcome. But that was interesting. On top of that, another thing that happened since I made my video about this was 3 parties have indicated an interest in filing briefs in support of the parties in the appeal. So those are called amicus briefs, and those are basically other parties who either have an interest in the outcome or interest in the outcome. They could file briefs, even though they're not parties, and the court will consider them. So there's been 3 requests, I think, to this point in time. One was by the American Municipal Securities Board, which is also an SRO. So it's the equivalent of like FINRA organization. It's basically a government-affiliated organization. It does similar work to FINRA, but only with regard to the bonds. And it took a position, basically, that FINRA, whatever FINRA did, they were entitled to, and that those are the rules, etc. In about 50 pages, by the way. But that's what they said. At the same time, or subsequent to that, there was a Wyoming entity called, I have to find the name of it, the American Free Enterprise Chamber of Commerce, who filed a brief. And they, although they're not supporting Alpine per se, they're supporting Alpine's position. There's a third entity that has yet to file their brief, but has requested permission to do that. That's called the New Civil Liberties Alliance. And that's, I looked it up. I would say it's somewhat of an anti-government organization. So I would expect them to, again, not side with Alpine per se, but side with Alpine's position. So the court will have these, and there may be other parties that decide to file briefs in support or against the parties' positions. But eventually the court will get these briefs and consider them, and maybe when oral argument, if there's oral argument, they may ask them questions about them. But it's just in the ordinary course. Now, again, not all appeals get amicus briefs filed with them, but as me and little Mr. JR have said, we think that these issues that are going before the U.S. Supreme Court are huge, and that that's why parties are joining in, because they understand that there may be law made as to the authority of both the SEC and FINRA. So again, that doesn't change Alpine being scumbags. It only talks about the duration of their being able to exist as an entity. I don't even know if they're doing business at this point in time, but for our purposes, they currently still have status. So that's that. Now, last but not least, and again in reverse order, is there was a First Amendment complaint filed in Gtii versus Canaccord, etc. It's the original complaint was filed a few months ago. The way this works is complaints filed if the defendants, and there was Canaccord, GTS, I think 3 small brokers or agents. The 2, Canaccord and GTS, were market makers, or alleged to be market makers. So all those parties are named. They were served or provided the documents. They indicated they would file a motion to dismiss, as opposed to plaintiff, which would be in this case Wes Christian, who is representing plaintiff, as opposed to them wanting to just duke it out over the motion to dismiss, which doesn't make a lot of sense. They said, can we amend the complaint, the original complaint? Not unusual, happens frequently. The other sides agreed, so they filed a First Amendment complaint. That is what is now before the court. It was filed September 5th. So, in essence, the First Amendment complaint and the original complaint assert the same claims for relief. The only difference is in the First Amendment, there's a lot more detail, and it specifies the methods, means, mechanics of defendant's scheme to manipulate the stock price of GTII down, and it also more clearly demonstrates the harm that GTII suffered with regard specifically to 19 million shares that were sold. And it goes through detail of the various spoofing actions that occurred. So it's not significantly different from the original complaint other than it adds detail. It doesn't change the claims, but it adds more detail. And the fact that it has more detail, if you're the attorney filing the complaint, you think it has a better chance of withstanding another motion to dismiss, which will probably be coming from defendants at some point in time. They will have, usually it's 30 days to respond. I would guess they're probably going to file the motion to dismiss because they already did, and it'll go from there. So that's basically what happened. And basically the claim is, as it was in the original complaint, as it is in the first amended complaint, that all these guys, so the market makers with the assistance of these brokers, are spoofing using algorithms. What they're doing is they're doing this super fast trading where they're purporting to sell the security, even though they're not really doing it. So they are basically using, I guess they call it baiting tactics. So it shows up like they're selling, but through the algorithms, they are able to cancel those sale orders, but you, the public, think they are selling, so you then sell, which decreases the price without the bad actors having to do anything. So why would they do that? Maybe they might have a short position, or maybe they want to buy the stock at a lower price. But anyway, in this case, those are the allegations. And apparently this occurred over 19 million different shares that were sold. And this claim of spoofing is alleged to have violated federal law. And that's the basis of the action. So the complaint seeks damages. The damages would go to the company, because that's the plaintiff, and maybe to the benefit of the shareholders indirectly. But that's really the change. So no substantive change, more factual detail. Again, it was basically a bait and switch. If you want to look at it that way, it's a bait and switch tactic. This is what we're going to do, but they really weren't doing it. They used the mechanics of fast trading to fool the public, give them a false sense of supply and demand, and took advantage of that. And that's what the claims are. Now, and we'll follow that. We'll follow the procedure as they file. I'm expecting motions to dismiss. Now, one thing what's interesting, just as a side issue, is those two market makers are also apparently the two market makers with regard to the unlawful trading of MMTLP. So I think that's interesting. Maybe that'll come out in the GTII proceedings, or maybe it'll come out in the MMTL proceedings. But that's kind of the sum and substance of the new complaint. I don't think there's any no great change in the procedure or the status, and I'll keep you apprised. And then anybody else out there is listening, be well, share this, take care, and we'll talk again soon.